A very good morning, ladies and gentlemen, dear colleagues, dear users of the Benelux IP system, welcome. Very nice that you joined this webinar today. First of all, we hope that you and your beloved ones are in good health and in good shape. This endless pandemic forces all to adapt ourselves, and this is actually the best we could imagine to replace the huge IP conference we had on our plan for this year. You know it, at BOIP we find it important to play a role in knowledge sharing. So this is the first of three BOIP webinars, one of three. Starting this week, we give you rendezvous each Wednesday at 11 a.m. sharp to tackle different subjects of IP. And the first one, today we will actually tackle two topics, two subjects: cancellation proceedings and the new competencies of the Benelux Court of Justice. And we will have two excellent speakers, of course, Dieter Reutens for the first subject and Saskia Smith for the second part. I will not speak any longer. I wish you a fantastic and wishful moment. Thank you for joining. Only a very last practical point. At the end of the session, you will be invited to give your feedback, your experience with this session. Please take a few seconds to share this with us. It's important that we hear from you as well. Take care and see you soon.
A very good morning and a warm welcome to the first, like Hugues said, 3 webinars we're organizing in the coming weeks. For this first session, we decided to look back and see how some of the changes dating back from June 2018 are working out. This webinar has been divided in 2 main topics. Like Hugues said, first we will go into more detail regarding some procedural matters and give you some pointers relating to the cancellation procedure. And I will follow with a short recap of some of the office decisions we have rendered and lessons that can be drawn from them. My colleague, Saskia Smith, will then continue with an overview of the first experiences and cases from the Benelux Court of Justice. There will be, of course, the possibility to ask questions, but since we're not here looking at each other in the eye, it will be done via the chat, and we will try to address your questions as best we can at the end of the session. Now, for a brief overview of what's changed in June 2018. The protocol of the 16th of December 2014 regarding both opposition and cancellation entered into force. Subsequently, following the implementation of the so-called trademark package, the grounds which can be invoked were enlarged. The grounds can be categorized in 3 groups: grounds for revocation, absolute grounds for invalidity, including bad faith, and relative grounds for invalidity, including the new grounds based on PGIs, PDOs, as well as trademarks filed by an agent.
Yes, then we make a small comparison with opposition. This webinar is of course not about opposition, but it's nice to point out that there are new grounds in opposition as well. The possibility to invoke a trademark filed by an agent, a PDO, BGI. We have the new ground sub C, as we call it, that is trademarks with a reputation for different goods and services. And it's important to point out that bad faith is not a possibility within the opposition procedure.
Exactly, thank you. I think this is one of the main differences. And actually, if we look at some numbers, we thought it might be interesting actually to give you the possibility to share maybe your estimates. If you can, I would not call it a guessing game, we called it the number game, but probably based on your experience, you know, or you have an idea on how many times certain category of grounds were invoked the most. So we prepared a little poll for you. And we're asking you which of the previous categories of grounds, so revocation, absolute grounds, or relative grounds for invalidity, were invoked the most. So I'm looking at our technician, whether or not we have the poll in place. If this is the case, then I would like to have your votes. Do you have any idea, maybe Saskia, while we're waiting, what would be your guess?
My guess would, I think, 2 absolute grounds. A second chance, maybe.
It might be an interesting one. The absolute grounds for invalidity because of the fact that it's after the initial refusal period. It's maybe the second chance, and we have, of course, the trademarks prior to 1995, which weren't examined by the office. So could be an interesting one. I think, of course, relative grounds for invalidity might be one as well. We do see that the opposition term might be a bit limited for certain people.
Well,
So-
indeed, we had some cases where the opposition term was missed, and therefore a cancellation was filed. So in practice, we see this.
Yeah. So I think we've given you enough time to come to your response, and actually we see that relative grounds for invalidation were the ones who were picked the most, with 42%. I'm sorry to say that the ground that got the least amount of votes is the revocation ground. Is actually the one that is being invoked the most often. I wanted to go to my next slide, but apparently there's a problem with the technical. Moving on, I was going to show you a very nice bar diagram to prove that I'm actually not lying to you. Here it is. So revocation, it's a close call, I'll give you that, with the relative grounds for invalidity, but still the revocation won. And probably not, I mean, although we had arguments in favor of the others as well, it might not come as a too big of a surprise because of the very popular ground of lack of genuine use, which was, of course, also one of the reasons the cancellation procedure was put in place. We actually have, I'm tempting the technical strengths of this webinar, I'll give you that. We actually have another poll for you, which would be the choice between bad faith and trademark filed by an agent. Maybe just for the fun of it and quite quickly, these are 2 very special cases that we now know in cancellation. Do you have any idea which one was invoked the most often? We'll give you an opportunity to respond to that. Do you know, Saskia, if it happens a lot now because the trademark filed by an agent, it's now a ground in opposition as well?
Yeah.
Is it used a lot?
No, it's not used a lot. In 2019, we had 1 case, and in 2020, we had 1 case. And they are still in the beginning of the procedure, so not yet in the argument phase. So wait and see what comes from it, because it's a real new procedure for us.
I think we can quickly skip to, I don't know if you all had the time to give us your answers. So bad faith is the very, very clear winner. There was just a couple of people who still, maybe after the arguments of Saskia, switched to the trademark
file.
switch to trademarks filed by an agent, but indeed bad faith is here the clear winner. If I show you the diagram, you will see that it was invoked 19 times compared to only 2 times for the special ground trademark filed by an agent. So now this for the more interactive part and the number game. We will have some number games later on still when we talk about decisions and court cases by the Benelux Court of Justice. But now let's move on to some more procedural matters relating the cancellation procedure. So when we're talking about practical aspects, the first one, of course, is the filing of an application. You will have noticed that it's still a quite old-fashioned way of working here at the office. So therefore, we kindly ask you, we're not making it obligatory, but the filing of an application for cancellation, the use of the PDF form, which can be found on our website, is the preferred way to file such an application. This is mainly the basic part. We have seen in some cases, especially in cases related to absolute grounds of invalidity, that certain attorneys already file their arguments together with the application itself. That is perfectly possible. It might actually expedite the proceeding in certain cases, especially in absolute grounds and relative grounds of invalidity. But please beware, we still have a step to take with the language of the proceedings. So if you're not sure about the language of the proceedings, then actually it doesn't make a lot of sense to already file your arguments together with the application form. When we talk about, it's actually a slight, might be slightly different from EU-IPO, and actually the two other points on this slide are also differences with the practice from the European office. Firstly, it's about the suspension. We can only, apart, of course, from the other suspension grounds, the request for suspension needs to be done by joint request. We do not accept unilateral request, as does the EU-IPO. I think for the first time you ask for a suspension, you are granted it unilaterally. This is not the case at the Benelux office. It's only by joint request. Also, contrary to EU-IPO, our implementing regulations only foresee one round of observations per party. Of course, there are some corrections to that strict rule. One is, of course, that the defendant always has the last say. And the other is in case of when lack of genuine use is invoked as a ground, the defendant will have the last say, but if he invokes or actually files more evidence which might impact the outcome of the decision, then of course we will reopen the debates and give the claimant the possibility to respond to those. But this will be done when we actually study the file for decision purposes. Now, back to the procedure itself. I already touched upon quite shortly the different categories of grounds that can be invoked and the differences that might occur based on the ground you invoke. So just some theory here. Rule 131 paragraph 1 talks about all the claims based on all the grounds except the revocation ground for lack of genuine use. And Rule 131 paragraph 2 is the one that actually sets out the procedure when the case is only based on lack of genuine use. So that's the theory. You can all go and look it up, not now. You can all go and look it up in the implementing regulations, but I thought it might actually be nice to show you simplified schematic of the procedure, and it's up on the screen now. It's if we look at the first one, it's the 131 paragraph 1 I just mentioned. It's a very clear-cut case. It's very simple. If it's based on absolute grounds or relative grounds of invalidity, it's quite simple. For the relative grounds of invalidity, you will notice that actually it resembles the opposition procedure quite well. So after the language of the procedure has been determined, that's always an obligatory step. The claimant has a period of 2 months to file his arguments, after which the defendant will have 2 months to respond. If, and that's the gray part on the slide, if the defendant asks for proof of use of the invoked right, then the claimant will get 2 months to file the requested proof, after which the defendant gets his 2 months to respond to the evidence files. If he hasn't filed arguments yet while requesting proof of use, he will have the opportunity to do so when replying to the claimant's proof of use. For the lack of genuine use procedure, it is different. The defendant is requested to provide proof of use immediately after the communication on the language of the proceedings, but beware, if we can actually fixate the language of the procedure immediately, then with the notification of admissibility of the procedure, the defendant will immediately get his 2 months term to send proof of use, so which is actually quite quickly, but it's also one of the reasons why we send the notification of admissibility by registered mail, so we are sure that the defendant gets the mail and is allowed to have his 2 full months to file his proof of use. So this, in a nutshell, how the procedure works. I talked about proof of use and the proof of use filed by the defendant, more specifically when it comes to lack of genuine use. This is a bit of a sneak preview I will give you. I will briefly touch upon a new rule which will enter into force on the 1st of December of this year, so in a few days, and regarding the introduction of proof of use. In the webinar next week, our colleagues who talk about the trademark package, very interesting webinar. I would suggest you all register for that one as well, because they will also more extensively go into detail about this new rule of the Director General. I will just summarize it quite quickly. It's actually a result of maybe people not really listening to what we said in the previous webinars or workshops, where we emphasized that it's actually quality over quantity, and it's really not necessary to send us boxes and boxes of proof of use. That really did not bear fruit. The picture you see on the slide is literally my office. So this was one evidence that was filed in one case, in a cancellation case. You can imagine how difficult it will be, not only for the other party, but also for the office to come to a decision, and that it will take time. So for the benefit of all parties involved, and to actually to make sure that we get all the information we need and we take the right decision, which is, I think, still the way everybody would want it to work, we are asking now for a structured and numbered bundle with a table of content, a brief description per piece, and the reason why it was filed. And also, if the piece in itself is not clear, then it should be highlighted what element of that piece is relevant. And in the arguments, we would want a concrete reference to the evidence. But like I said, my colleagues next week will go into more detail about that. And you will have the opportunity there to ask all the questions that you will probably have on this. Now, you've heard enough about me for the moment. I will give the floor back to you to wrap up this procedural part. And before we go to the decisions part, I was wondering if you have an idea of the percentage of the cancellation decisions that have been awarded up until now. So we have a couple of options for you. I didn't make it very easy. So this is for the people who have been looking at our website, and I made it extra difficult because we actually rendered a decision yesterday. So this actually changed the percentage. So even if you were very up to date, it might be quite difficult to get the answer right. So Saskia, would you make an educated guess?
Way too informed to make an educated guess. I would give it away.
You would give it away. No, we don't want that. We would like your input on that. I see there are still results coming in.
They're in doubt.
Yes, exactly. It's a close call. I think, yeah, the 56.3% and the 65.4%, they are quite close. And if you look at the percentages for oppositions, I think we're along those. This is excluding partially awarded, so this is just the.
Now everybody is changing again. Oh no.
No, they can't. They can't. So that is. So we have 84 answers in total for the moment. So I think it's time to see who got it right. So the right answer was 56.3 up until today. So that's 34 of the answer, 40%. So the majority had it right. So up until today, 32 decisions have been rendered, of which 18 were awarded. 3 were based on absolute grounds for invalidity, of which 1 on bad faith. I will come to that one a bit later, but you probably all heard about it already. 9 were based on lack of genuine use, and 6 on relative grounds for invalidity. Maybe on a side note here for your information, when we're talking about decisions, sometimes we get calls when a decision will be executed. Decisions are only executed by the office once they have become final, that is, after the expiration of the appeal period. So for international registrations, because you can also file a cancellation against the Benelux part of an international registration, this notification of the definite decision of the office will be the first and only point in time when WIPO will actually publish something in the international register. So please don't be surprised if you don't see a provisional refusal like you would expect in oppositions during the course of a cancellation procedure before BOIP. That is quite normal, and it's just following the rules emitted by WIPO. Now, for some decisions and some lessons which can be drawn from them, I will be very brief, but I think it's good to emphasize some highlights, I would call it, or maybe some lessons, some rules which might be actually beneficial for your future experience with the invalidation procedure. In this case, the amazing case, which was an amazing case, of course, the claim for invalidation was directed against the word mark amazing for goods in class 31. Generally speaking, it was a bit broader, but generally speaking, plants and flowers. The claimant argued that the word amazing is an existing word, meaning, among others, astonishing. He didn't really reference any dictionary and any source of this information. He just stated that it meant this. And he also said that it was used more often with regard to the goods at hand. And he showed us some elements in support of that. He then considered that it was a laudatory word, which is actually more or less at the same level as super or mega. However, these claims were not substantiated by any element proving that indeed this word had this meaning, or that it is considered to be descriptive by the relevant public in the Benelux, which is, and we've seen it in other cases as well. So referencing a foreign dictionary in itself is not enough. It's not enough that the word exists. We really need the claimant to prove that indeed the word is descriptive and will be considered as such by the public in the Benelux. We had a similar case. It was a figurative mark, but the discussion was also related to the word elements, which was pure draft, where we had the same issue. So it is very important in cancellation proceedings, and it's the same in oppositions, but even more so in cancellation proceedings, especially when you're asking to invalidate an already existing registered trademark, to not only claim, but also prove your statements. Now, of course, the One World decision, everybody will probably already have heard of this one. It's quite recent. It's from the 20th of October 2020, and which was, I think maybe, if I'm allowed to say it, coming as a co-signer and coming from the office as well, but quite the landmark case when it comes to bad faith, especially for our office. Like I said, since I'm one of the co-signers of the decision, I will not go in too much detail about the case, which is still subject to appeal. But what I can say is that based on the relevant case law of the Court of Justice, specifically, I mean, they are mentioned on the slide, but specifically the very recent Skykick case as well, we came to the conclusion that based on what the claimant showed to be a pattern of behavior of the defendant, which was really not contested at all by the defendant himself. The defendant himself only stated that he saw value in the trademark and that he's a very, I think his words were, versatile entrepreneur. But there was nothing actually contesting and explaining this pattern of behavior of the claimant. So based on the case law of the Skykick case, we decided that in this case there was bad faith involved. And then the last one, for my part, would be the very, very recent, it's the case that was published yesterday, the very recent case Pizza Italia, which was also a special case, as it was not only based on relative grounds for invalidation, but also on the absolute ground of bad faith. And what is very special in this case might not be the bad faith, because we touched upon the bad faith, although we didn't have to do it because we followed an economy of proceedings and we already concluded that the trademark needed to be invalidated based on the relative grounds of invalidity. So there would not be any other outcome. Invalidation is invalidation. It would have been different for revocation, but for invalidation, there is really no difference. So we didn't need to go into detail about bad faith, but we did state that, again, we noticed that the claim of bad faith was there, but it was really not substantiated enough. Actually, the very interesting case, and also for your practice, would be the double burden of proof of use, because actually here, because the invoked right was registered a while back, what we needed to do was not, the claimant did not only need to prove use in the period prior to the cancellation action, but seeing that, and I think the dates were, I think the claim, the invalidity claim was filed on in March 2019, the contested trademark in October 2015, and he relied on a trademark for, I think, applied for in 2009 and registered in February 2010. So there's a double burden of proof in this case. And so not only 5 years prior to this cancellation action, but also 5 years prior to the application date of the contested trademark. So this is an important element for you, meaning, to put it briefly, I think it's already, it's in the Benelux Convention, but it would actually be a case where you miss the opposition, and if during that opposition procedure you would have had to prove genuine use, then you will have to do it also here in a cancellation case. So I think this is it for me for the cancellation procedure, and I think I will give the floor now to Saskia.
And
because
I
of
have
the
yes, one moment.
everything, you will see that we're at a certain distance.
Yes, thank
Yes.
you very much. Thank you very much. Well, not only thank you for the pointer, but thank you for the very vivid and interesting presentation as well, as we are used from you. Hello to you all. It's a pity that we cannot see each other. I can not see you, unfortunately, and I hope that in the near future this will be different. But I hope that this will be interesting as well. And in this part of the webinar, we will talk about the Benelux Court of Justice and the first impressions we have on the procedural aspects. And we will discuss some interesting cases with you. And I have to, yep. Just a small reminder, and as a warming up, since June 2018, no longer the 3 different national courts are competent for the design and trademark cases of the office, but it's the second chamber of the Benelux Court of Justice. And all playing rules can be found in the procedural rules of the Benelux Court of Justice, and we have no competencies in that aspect. But we can share with you what we have seen up until now in practice. No? I have to point somewhere else. Yeah, I did it. Well, as for the procedure, it's fairly new, only 1.5 years, and not everything has been formed yet. Last year, during our seminar, we had a very clear and informative presentation of Mrs. Kiers-Becking, who perfectly explained the particularities of the procedural rules. And she referred to the fact that day-to-day practice had to form the system. And in this webinar, we will see what the day-to-day practice has been. On the first point of representation, formally, the representation could only be done by attorneys at law before the courts. And now in the procedural rules, it is stated that the court can allow parties to act as a representative. And in practice, we see actually that trademark representatives are acting before the court. Another very practical aspect is about the language. In Article 1.6, it is stated that the appellant determines the language. This is a bit different from the procedures we have at the office, where it is mostly, in general, the defendant who is leading in the language. But I will not go into the exceptions on that side, because this is about the Benelux Court procedures. But we do see, and we were there present, that the way that the languages are dealt with is very practical. During an oral hearing, one can make use of its own language, and the judges do the same. This is possible because interpreters are always present at those cases. A very strict rule is the paper submission of the arguments and the evidence. It needs to be on paper, therefore by regular mail. However, we see that in practice it is very much appreciated when arguments and evidence is sent by email. And this is for the ease of the registry, because they can use those documents for translation purposes. Well, what we see is that the procedural rules are of course leading, but have been given form up until now in a very practical and accessible way. We noticed that the communication with the court registry is informal, open and pleasant, so that helps us a lot in our own administration. For example, the court registry informs the office if an appeal has been lodged against one of our decisions. So there is a good interaction between the office and the court registry. Well, up until now, in actual numbers, 59 appeals have been lodged, 36 against oppositions, 9 against cancellation, and 4 against the decision on refusal. 3 judgments in refusal were rendered, no judgments on cancellation so far, and we have received 18 judgments on opposition cases. And then, because we are in the mood for number games, I hope you are still tuned in. We have one last number game. and that is about the percentage of confirmed cases by the Court of Justice. And I'm going to do the exact same thing.
Knew it.
Your
I knew I was going to
educated
expect.
guess, please.
Well, my experience is mainly related, cancellation proceeding, we don't have any cases yet. And for the refusals, I'm very happy to say that for the moment, the court has confirmed all 3 of our cases. We don't know from experience that in opposition cases before the different national courts prior to the Benelux Court of Justice, this was not the case. Yeah, taking into account the oppositions, I would tend to, what were the percentages for these? I don't know, I think 59. I think a lot of people, if based on the responses, a lot of people have faith in the decisions by the office. It's actually a very warming, maybe now the percentages are going to change, yes. No, but it's actually a very warming thought that apparently the decisions the office renders are being appreciated.
Well, I think we have now 78 answers, maybe some more.
I think this is it. 79.
And yeah, 79. Thank you very much for interacting. Well, the right answer is 47.6%.
Shame.
Such a pity, indeed. We had 3 cases on absolute grounds confirmed by the court. But in absolute numbers, we are satisfied because only 3 out of 21 cases were rejected. We had some settlements and we had some partial confirmations. We will now...
Maybe we should show the proof.
We should show the proof because it was hard to make the proof because
exactly.
I made a pie. So you see it here confirmed. Luckily, most, and then settled, rejected, and partial. Well, actually, we're now going to discuss some cases, and as Dieter was BOIP's representative in one of the cases on absolute grounds, he will talk about these 2 cases. I will keep the pointer, and I will do it for you.
Please keep the pointer. That saves a lot of valuable time, I think.
Yes.
So yes. When it comes to the cases before the Benelux Court of Justice based upon absolute grounds of refusal, I can actually be quite brief, surprisingly for me maybe, but the analysis of the court in the 3 cases we had so far contain no really surprising elements in relation to the appreciation of the distinctive character or the descriptive character of the signs. They do, however, touch upon a couple of subjects which have been, or which we've seen invoked, either in reactions to provisional refusals by the office, but also in the court cases, and which we thought might interest you. On the one hand, in the Sports Direct case, the applicant claimed that he was unable to acquire distinctiveness through use because of an earlier trademark in the Netherlands. There had been some use in, I think, prior to 2009, but he wasn't able to prove any acquired distinctiveness in the Netherlands because there was an earlier trade name in the Netherlands, and therefore the applicant alleged that the legal framework and the unitary character of the Benelux when it comes to trademarks was actually violating his freedom to conduct business as set out in the Charter of Fundamental Rights of the European Union. The court rejected this argument as they said that the claimant or the applicant is free to use his mark in Belgium and Luxembourg and is actually also doing so. So that for the Sports Direct case. We see something quite similar happening in the Pets Budget case, which I litigated indeed. It's where the applicant claimed that the burden of proof for the acquired distinctiveness through use for a Luxembourg national is actually higher than for example, a Dutch national. This argument was considered not to be relevant by the court, as no acquired distinctiveness through use in any of the member states of the Benelux was proven. Beyond the subject of violation of the Charter, and probably more important for your day-to-day practice, is that this judgment contains a recital on the criterion which is being used in assessing whether a trademark is distinctive or descriptive or not. And the court explicitly states, and I've actually copied it in English on the slide which is hanging above my bed, it's that there is no direct and immediate link necessary between the sign and the goods and services in question, such that the relevant public perceives immediately and without further reflection a description of one of the characteristics of those goods and services. It's something we sometimes see in court cases by the General Court, which has not really been confirmed by the Court of Justice and of the European Union, and which we actually find being in line with the, for example, the landmark Postkantoor case about the May serve. So we think this is a good outcome from this decision, which actually makes it clear that these signs which are have a direct and immediate link, yes, they are descriptive, but it's the scope of descriptiveness is indeed wider. So I think this is it for the refusals.
Okay, thank you. Well, no cancellations to discuss, so we go to the opposition cases. The first case was Business Royals. This opposition was based on a well-known trademark under Article 6 bis of the Paris Convention. And the office has rejected this because the evidence submitted was not sufficient to substantiate this claim. Then the case went to court and we were confirmed, and the mere claim of worldwide sales was not enough according to the court. Documents such as a market research or date and place indications were missing from the evidence, and there was an argumentation with a list of registrations that there were worldwide trademark registrations that were maintained. The court said in this that's not enough to prove that the trademark is well known. The substantiation was not enough, so our case was confirmed, and this is what we saw in the cancellations as well. Substantiation is a red thread through all the decisions of the court. In Toxicon, again, substantiation was very important because this was really the game changer in the end conclusion of the court. The invoked right was in Cyrillic script, and we, the office, were of the opinion that the signs were similar because we stated that a part of the public was familiar with the Cyrillic script, and therefore orally there was a very strong similarity because Toxicon is the contexted application and the Cyrillic script was Toxicon in Latin script. So we held the trademarks therefore to be similar. Then the case went to court, and the argumentation and substantiation of the appellant was convincing to the court. He stated that the Cyrillic script is not known to the public concerned. The defendant did contest it, but he did not substantiate it. And therefore the court said the signs are similar to a very low degree. Maybe some letters of the Cyrillic alphabet are like the Latin alphabet, so maybe there's a low degree of similarity. But there was some similarity, not a lot. The services were considered similar, but then in the overall appreciation, the court stated due to the higher level of attention of the public concerned and the specific differences between the signs, although the goods and services were similar, there was no risk of confusion. Well, then we already come to the last case in this webinar. That was a case about genuine use. We rejected this opposition because in the evidence we saw that there was only evidence for coffee, in our opinion. And then we compared the coffee, the goods coffee, with the goods and services of the contested applications, and we were of the opinion that those were not similar, so we rejected the opposition. The court had another opinion. They considered sufficient proof of use was provided for coffee and tea and cocoa. The contemplations about cocoa are very nice because firstly they had chocolate and bonbons, and they said no, this is not a sufficient proof for cocoa because the goods are different. But there was also proof of use for cocoa powder for the preparation of beverages. And the court said this is a subcategory of cocoa, so therefore we go for coffee, tea and cocoa genuine use. Then they made a comparison of the goods and services. They were found to be similar for some goods and services to a high degree and similar to a low degree for other goods and services. You can see it on the slide. Herbal infusions and spice mixes were considered to be similar to coffee, tea and cocoa. And the court made a comparison between the trademarks. The trademarks were similar to an average extent. And in the overall appreciation, the court stated that for the similar goods and services, the opposition was accepted. And for the low similar goods and services, it was rejected. So we see here a very good balance that was made between the well, now I know the word in Dutch but not in English, but we will not do a word game instead of a number game. But you see that the higher the similarity of the goods and services, the lower the similarities of the signs can be to accept an opposition. Well, this brings us to the end of the content of this webinar. There is a possibility to ask questions through the chat.
I think we
and
have,
I think we have a very nice secondant. So there are three questions, if I understand.
Yeah, we have some time left.
Okay, very good.
I think we have one question by Andre. I think I will take this one.
Yep.
When will it be possible to file or manage cancellation actions via my BOIP? Yes, this is a this is a personal question I have as well. So thank you. Unfortunately, because when we put in place the cancellation proceedings, this was together with our a big project in our office, which was the back office trademark. And therefore, we didn't really implement anything, or we implemented a very light version. We are talking about the planning for next year, and it is quite high on the list to at least have an e-filing and hopefully also something more. The My BOIP actions, it's very high on the wish list as well. But we have a lot of projects we want to do. We want to make a lot of improvements, and we're trying to find a balance between projects which are beneficial to most of our users, and also we're looking at numbers. And unfortunately, with up until now, we have 263 cancellation actions since June 2018. I do my best, but it's not easy to convince our IT department that it has to have a huge priority, but hopefully next year you will see some improvements already.
I think the second question is
also for me.
For you.
So Pierre-Yves, is there a discrepancy between the BOIP's burden of proof of use, often very limited evidence of descriptive, and I can't see, customary nature of a sign is provided in the
standard refusal letter?
Standard refusal letter versus the burden of proof imposed on the applicant for invalidity. With a smiley. Thank you for the smiley. I think it's standard case law by the Benelux Court of Justice as well, that when we indicate in the provisional refusal our reasons and we enumerate the article numbers, that is already a sufficient reasoning. We try to do our best to explain as best as we can the reasoning behind it. But yeah, based on the case law, this is fine. For the invalidation of a descriptive name, it is we found, usually if we're talking about trademarks after 1995, there has been an examination by the office. It is a registered trademark, and there is a third party claiming that it is descriptive. Just filing an application saying it is descriptive without actually saying anything, not giving any reason behind the filing of the application is not sufficient. You will see, if you look at our refusal cases, you will see that maybe the first letter that we send is quite brief, but in the reactions we send out, we really go into every single subject in a detailed manner and actually give examples of how we found it and how it should be interpreted according to procedural rules or CP programs, etc. So in this case, I see you're referring to the amazing case. It is clear that the claimant there just said, it's an English word, and oh yeah, by the way, I see it in Pinterest being used in relation to flowers. Yeah, if someone says this is an amazing bouquet, that does not mean that the word amazing in itself cannot function as a trademark for flowers. So there needs to be substantiation by the claimant in order for the office to actually invalidate. It is clearly not the competency of the office to redo the refusals. So we cannot do it ex officio. I see there was a Pizza Italia question. It's not a typo. It's not a typo. The decision can be found on our website. Please read it. It's Pizza Italia. So the A at the end is indeed missing. Yeah, I'm sorry, Saskia.
Yeah,
it's
no problem.
Apparently,
then I was clear.
apparently you were clear and I was not. So that'll teach me.
No, I fully understand the questions coming to you.
So there was a question by Marloes. If a cancellation action is based on more than one grounds, a combination of revocation as well as relative grounds, can the relative ground be withdrawn at any time? And if so, will this change the proof of use delivery during the cancellation procedure? You can at any time limit the scope of your cancellation, and of course, based on the moment in time during the procedure, this will of course change whether or not you will need to deliver proof of use. So I hope this answers your question. I think these were the three questions we received, where I had not expected it, but
we're spot on.
We're spot on. Representation before the Court of Justice, Saskia. There's one by Ade. do I understand you correctly that trademark attorneys, medekegemachten, are allowed to represent parties?
Yes, that's indeed what we see in practice. We have seen known trademark attorneys, representatives acting before the court.
Yeah.
So yes,
It was actually in the PETS budget case.
Oh yeah, that's where you.
It was the trademark agent who actually represented his client before the office, who also took on the court case before the Benelux Court of Justice. So it is indeed possible. 2 minutes left on the timer. I see there's another message coming through, so our assistant is working as hard as he can. Benedict, would you consider some sort of guidelines incorporating the new decisions and grounds? Yes, we always consider and contemplate guidelines. It's maybe a shortcoming at the moment on our side when it comes to the adaptation of our guidelines. We're working on that. We're involved in a lot of projects internally as well. Good news, if you tune in for the third webinar, so in 2 weeks, we will be presenting you our very fresh and new guidelines on absolute grounds. So I would suggest to have a look at what Pieter Weese and Eline Schieber will tell you about that subject. And in the meantime, I can already tell you that we're working on an update of the opposition guidelines. And of course, we would like to have cancellation guidelines as well. It's on the agenda, but unfortunately, I cannot give you a definite timeline yet. Another one where it's 12, so I think this will probably be the last one, unless there's one for Saskia left, of course. Could you add cancellation grounds after already filing the notice of cancellation action? It's actually, you can add, it's stipulated in the form, and we mention it also on the summary which we send with the notification of admissibility. You can do so until the claimant can do so until he files his arguments. There was an exception when we when the subsequent grounds were added for the trademark package, so we had a possibility there as well. But now it is only limited to the moment where you have to file your arguments as a claimant. Up until that moment, you can extend. If there's an additional fee to be paid, you will have to pay the additional fee, sorry. But it is possible. After that, it is unfortunately not possible. So I think that is it. Thank you a lot for your questions, your interactions, and helping us making this, I think, a very nice first webinar.
Absolutely.
You will be invited to fill out an evaluation form at the end. Please do so. It's very, very short. It's just a rating, and if you have any suggestions, other topics you would like to see addressed in the future, please do so. And I think I will give you the last words.
Okay, thank you. Then it only is for me to say thank you very much for your interaction, for your time, and still looking forward to seeing you in real life soon. Bye-bye.
Bye.